Welcome to Bond University on iTunes U.
Thank you. I think I have Guernsey for being the first to reply to Her Ladyship. It's nice, isn't it, to hear some positive stories about the kinds of encroachments upon people's liberties that we have been discussing today, and which can be depressing and demoralising when one looks at the personal impact that some of these measures have had on vulnerable people. I think it is worth reflecting upon the checks and balances, and it's in that regard that the talk we've just heard is both thought-provoking and inspiring, because we in Australia have modest numbers of these checks and balances, and in any country at any given time only has modest checks and balances. What Her Ladyship called the Murdoch shadow is a very real factor, because a potential check and balance is an active and independent, highly performing media. Yes. We only have a modest component of that these days in Australia. England, as we well know, has only had a modest component of that as well. But if we are to learn things which people are prepared to let come out quietly to those whom they trust, and if we're to learn from those who are in a position to analyse and evaluate, we are very dependent upon the Fourth Estate to assist us to do so. And I think the message there is just how much we must protect and nurture a high-quality, independent set of media outlets. And if we don't do that, the consequences, as we've seen, can be that they arrogate to themselves powers and practices which are incompatible with human rights and also do not achieve what we might aspire to have them do by way of being a check and balance. We can see from the two examples that have just been discussed too that in our own era there has been latterly a new phase of moral panics, and one can track back 100 years and more and see a series of different panics about different phenomena which have engaged the public imagination and engendered public fear and resulted in harmful and unhelpful measures being taken by legislatures. What we can say confidently is that there will be more of those. Perhaps the challenge for us is to confine those moral panics as best we can and to intrude into them as quickly as possible some data so that the panics do not too readily translate into the kinds of sentences and orders which Her Ladyship has just described to us. I must say I don't quite share her optimism about the transitory nature of these phenomena, because we can see in the United States that the phenomenon of increasing numbers of detainees has been sustained over a lengthy period now. And it's my own experience that when rights are lost, they are very difficult indeed to regain. And we can see in our own country at the moment the growing momentum toward law and order politics, which has as part and parcel of it a deprivation of people's liberties. And if one thinks back over the last 20 years, I can't immediately recall any liberties really coming back. The closest that we have as an exception to that proposition is that in two jurisdictions in Australia we have had the introduction of charters of human rights. Those in our country, sadly, have been a very modest success because in the Australian Capital Territory and in Victoria, the charters have almost no teeth. The positive aspect to them is that they have engendered a more rights-conscious awareness within Parliament and within the bureaucracy, and to a degree within the general population. However, governments have continued to feel free to derogate from the stipulated human rights where the public interest has so demanded, or at least where they've told us that the public interest has so demanded. It would undoubtedly be a tremendous bulwark and protection were we to have even that level of protection of human rights that exists in the United Kingdom, never mind that which exists in the United States. But what we know from the United States and Canada and New Zealand and the UK and Europe generally is that even where those protections do exist, still bad things can happen. And in spite of the independent judiciary and the efforts of rights advocates and activists, dislodgement of major encroachments is a challenging exercise indeed. So protections where rights are taken away lie in our ability to see into the crannies and the nooks and the areas which are the subject of the deprivations of rights. The media I've mentioned already. Undoubtedly, independent monitors play an absolutely vital role. But I did describe them as independent, and there is always a risk that governments will appoint people who are tame, who don't go to the media, and who undertake a lip service exercise pursuant to their appointment. Politics intrude in every way, and although our countries all have reasonably independent appointees to the courts, we would be naive to think that the judiciary is depoliticised in any given era. And so the process of appointment of judges and continuing commentary on their performance again constitutes a very significant check and balance. It is interesting, isn't it, that it was New Labour that introduced both of these reforms, and the Labour Party has traditionally been much more associated with rights discourse and rights issues than the other side of politics. But I think that's something that one could debate. Certainly recent experience would, in the United Kingdom would lead one to think otherwise. Whether our country is replicating that phenomenon, I think it's dubious, but time will tell. One of the really problematic elements, it seems to me, when there is the institution of these kinds of regimes that we've spent our day talking about, is to gain a genuine and meaningful understanding of what is taking place pursuant to them. And let me give an example. The general population knows very little about what takes place in prisons. The general population doesn't care very much, but every now and again is meaningfully affronted by the reality as against the Murdoch version or its equivalent. And that is again why what Her Ladyship said about advocacy is so important. And can I share with you a case that I found to be particularly inspiring from the United States, because I want to say something positive about the United States, from last year. There was a truly remarkable Supreme Court decision last year called Brown and Plata, and it arose from a challenge to the escalating numbers of persons being detained in the prisons of California. And the numbers are absolutely enormous of prisoners in that state, as in many other parts of the world. The challenge ultimately was taken to the United States Supreme Court, and there was a bare 5-4 decision which authorised an order to the government of California that it reduced its prison population to 137.5% of design capacity within 2 years. Now, you might say to yourselves, that's not all that radical, but given the escalation in numbers and the numbers actually involved, it was a truly radical and inspiring, important decision. And the rhetoric that backed up the decision from the majority, definitely not the minority, the dissentient minority, again was one which affirmed a variety of really important human rights. And the essence of what was decided was that when prison conditions degenerate to a point where physical and mental health facilities are grossly absent, that constitutes a breach of the obligation to provide punishment that is not cruel and unusual. It's a terrible way of putting it, but I hope you know what I mean. And the majority in the Supreme Court actually added a pictorial appendix to show exactly what they meant when they declaimed how horrendous the conditions were in some Californian prisons. It's a really important decision because it asserted and affirmed an entitlement of people who are very substantially disenfranchised in a whole variety of ways to still have basic dignity and basic human rights in terms of safeguarding their well-being, albeit that they are separated from the remainder of the community. So options to protect those sorts of rights remain, and when the reality of gross violations of such rights are made public, I think we still get the kinds of decent and concerned responses that presumably constituted the bedrock for the reforms that we've seen in the United Kingdom over the past 2 years. But in order to get to that point, we need to have the active involvement of persons who are aware and committed, the funding for this kind of litigation, which draws upon those human rights which do exist. We need to have media who are prepared to report things in a way which bears some semblance to accuracy and reality. And ideally, we also need sources of effective oversight, whether it be into prisons, whether it be into detention centres, whether it be into places where those who are subject to deprivations of liberty in one form or another, if they be in godforsaken parts of Victoria or in the outback in the Northern Territory or on islands in some way related to Australia. We need that kind of professional, informed information coming into the public domain so that ultimately the basic decency of the general community can result in political pressures which have had the happy outcomes that Baronness Stern has described to us. So I think what we can take from what Her Ladyship has drawn so confrontingly to our attention is that we go through cycles, and those cycles can be lengthy and unfair and unreasonable, and if we are to break them and return to measures which are more humane and more rights attuned, we need to be in a position to challenge and understand and appreciate the ramifications of what is taking place. And for those, we need the sets of checks and balances which she has described to us. Thank you.
Okay. I wonder if I can pick up on three themes from Baroness Stern's address, and I'll do so as quickly as I can, particularly in light of the fact that you'll notice that I'm the only one here with nothing in front of my name or after my name. So I only merit a few minutes. First thing I want to mention is that I started practicing as a barrister in England and Wales in 1989, when the prison population in England and Wales was less than 40,000. And it's very, it is noticeable that the increase has been so quick in such a short period of time. The indeterminate prison sentences for public protection, it must be remembered, were sentences that were imposed on people who committed offences which didn't carry life imprisonment. The sentence was applicable if you committed an offence which carried 10 years or more and there was a finding of dangerousness against you. So it represented the ratcheting up to life imprisonment on an automatic basis of offences which Parliament had previously deemed should only receive a determinate sentence of less than 10 years. And that theme, that protective detention theme, was picked up in control orders as well, but also has been picked up in the other area of preventive detention that's been the focus of this conference, which is mental health detention. One thing that is noticeable about what the new Conservative Liberal government has not done is that they haven't made any amendments to the Mental Health Act in England and Wales, which in 2007, again a new Labour policy, was modified significantly to extend the ambit of preventive detention on the grounds of mental disorder considerably. And there has been no suggestion that that is going to go. So control orders relating to terrorism modified. IPP sentences scrapped. Mental health detention, no, the ambit is still wide. So we do have to be cautious about the fact that there are still areas to challenge, and I'll come back to that in a moment if I may. But one thing that comes through from what Baronness Stern was saying is the importance of bills of rights or human rights acts, the mechanism which we've adopted finally from the US of at least having the ability to go to court and argue about things in fundamental rights terms. Now, it's been done in the New Zealand model of the strong interpretive obligation without the ability to declare statutes null and void, except in relation to Scottish acts, which can be rendered null and void if they breach fundamental rights, it's worth noting. And the importance of that is that it demonstrates that the armoury of civil society actually can benefit from having actions that can be taken by lawyers. You know, Ian, you do as well as you can with the tools that you have, but if you had the ability to take the challenges that can be taken in the United Kingdom, you would be a much more effective lawyer, I know that. And the reason why that's particularly important, to bring a theme that Ian mentioned, is because the Fourth Estate is not doing its job. And therefore civil society needs additional tools, and it's right to say that the Human Rights Act in the United Kingdom has been a significantly useful tool in that regard. But it has been perhaps fortuitous that the Human Rights Act in the United Kingdom coincided with the elevation to senior levels of the judiciary of judges who were willing to take human rights seriously. So Lords Wolfe, Lords Bingham, Lord Phillips, Lady Hale, the new President of the Supreme Court, Lord Neuberger, they're all lawyers who are engaged in human rights, having previously been engaged in civil society as well. But it does demonstrate that if you get good judges like that and you get tools such as the Human Rights Act, then we can try and at least lawyers play their role in civil society in trying to take actions against the current obsession with the risk society that the Ulrich Becks and Anthony Giddens have identified. The role of Anthony Giddens in this is one that fascinates me because not only does he identify the risk society, but he was one of the architects of the new Labour policy that led to the need to have things like the Human Rights Act, which New Labour itself brought in. It is all very confusing that at the same time as they were obsessed with all these anti-human rights mechanisms or actions, they introduced the mechanism which allowed the fight back. I don't quite know that they understood quite what they were doing. The other point second point that leads on from that actually is the value of the human rights framework in dealing with the questions that we've been discussing today. There is the duty to protect, as Baronness Stern identified. One of the things that we haven't mentioned, though, is actually the way that the bodies like the European Court of Human Rights have identified what the duty to protect is. And they've identified that actually it's a fairly limited duty to protect, because it's one that only arises in circumstances where you can say that there is an identifiable victim and a real and immediate risk of harm that society, through the police forces broadly stated, can reasonably take steps to protect against. Because if you look through the reasoning in the cases such as Osman against the United Kingdom, which establish this duty, because they accept the inherent unpredictability of human action is such that you can't impose a higher standard. So there is a duty to protect, but it's actually relatively limited. And the other element of the human rights framework there is the right to liberty and the right only to lose liberty in circumstances where it wouldn't be arbitrary to have your liberty taken away. And as Baronness Stern indicated, the case law from the Supreme Court in the United Kingdom has made the point that certainly in European Convention terms, there is no general preventive detention, because preventive detention is almost by definition arbitrary. So the European Court's limitations on that, demonstrating the value, I think, of the human rights framework, is yes, there's a duty to protect, but we can't take it too far because society actually is unpredictable. And at the countervailing end, you have the right not to be detained arbitrarily, and you can only be detained on a preventive basis if there is an identifiable mental disorder that is such as to justify your detention. Now, it's not a panacea, and there are weaknesses in the system. As Chris mentioned this morning, the concept of lifelong detention imposed by a court, as soon as you have a court involved saying lifelong detention, actually all the protection under the European Human Rights Convention disappears, because the court is willing to say, well, if a court has said lifelong detention, at least as an envelope, then we've met all the requirements of due process and so on. But the human rights framework at least provides the basis for discussion about this, albeit that I accept it hasn't provided all the answers yet. And the third point flows on from the first 2 points, really, which is that we still have this all-pervasive risk society that needs to be challenged. And there are certain areas of that that Baronness Stern didn't mention, which are part of the New Labour policy, which still need to be challenged. And the most pernicious of those, if I may say so, is the multi-agency public protection arrangements, which have not been challenged on human rights grounds yet and really do need to be seriously challenged. For those of you who don't know about the MAPA system, it basically requires the police force, in conjunction with probation services and so on, to have an active role in assessing the funding for release places for people coming out of detention. So people who the parole board wants to send to a hostel, or people that the Mental Health Review Tribunal wants to send to a hostel or to engage with services or what have you, have to go through the multi-agency public protection arrangements and an entirely administrative process for the approval of funding. In the first year of MAPA's operation, my recollection from its report is that it considered the cases of 47,000 people. It's huge. And if MAPA does not approve funding for a hostel or for some intervention that's deemed necessary by the parole board or the Mental Health Review Tribunal, judicial bodies, if the MAPA doesn't approve funding, the condition can't be fulfilled and the person can't be released pursuant to that condition. So if MAPA says no, and the parole board says, well, we're not releasing you unless there's a hostel place, you're not released. This is administrative preventive detention based on risk assessment entirely without any judicial oversight. It's pernicious and it needs to be challenged. And I would hope at some stage that the human rights lawyers who in the United Kingdom have been pretty active would wake up to the fact that there are still problems that need to be solved where a human rights framework would be very useful. So ultimately, there are still challenges. I agree with Baronness Stern that there are reasons to be cheerful and hopeful about all this, but we still have problems that we need to address, and that's in the United Kingdom where the Human Rights Act has made a significant difference. So I know down here in Australia and across in my adopted country of New Zealand, where human rights are not yet taken seriously, there are even more uphill struggles to come.
Okay, ladies and gentlemen, we've got 15 minutes for discussion relating to the issues raised and discussed in that last session. Firstly, Donald Grant.
I just wanted to ask Baronness Stern if she could perhaps comment about the matter that was mentioned regarding the use of Mental Health Act in Britain to detain people who have serious, regarded as having, I think it's serious and dangerous personality disorders. Because I wonder if that's a kind of DPSOA by stealth. Because I would imagine if you looked at... Is this on? It is.
Yes.
I would imagine if you looked at the people perhaps under DPSOA supervision in Queensland, there'd be quite a big overlap between them and the people being held under the Mental Health Act in Britain under the dangerous personality disorder matters. And they're held, I understand from my colleagues, in secure institutions for many years, quite often, for a period of years, albeit getting quite intensive treatment, which perhaps DPSOA people are not getting here. So there's some differences, but I think there's some overlap, and I wonder if you consider that makes a difference to the way we look at the figures in different countries.
Do you know anything about it?
Yeah,
Perhaps I'm sure that the matter you've raised is something of concern, but what I would say if it was a different sort of meeting was, why don't you write to me about it, and then I will ask some questions, and then I'll see how we can take it forward. But since you're not going to write to me about it, and I don't know enough about it, I think Kris will know about it.
yeah, can I do know something about it.
I thought he would.
One thing to note is that the DSPD units, as they're called, have been a failure, and they're being closed because they don't work. The reason they don't work is what typically happens is that sex offenders at the end of their prison sentence will be moved, quite often on the last day, the day when they're due to be released, will be moved to the psychiatric hospital under the Mental Health Act because there are transfer provisions. And if they're transferred whilst they're still serving, their sentence may come to an end, but by then they are deemed to have received a hospital order and their detention can be continued. So it's precisely the same as the Queensland statute, except you don't even have to go to court about it. It's an administrative transfer, and then the legislation deems you to have been given a hospital order in the first place, and therefore your detention can continue. And the second thing to note is that when the Mental Health Act of 2007 amended the 1983 legislation, which is still the governing legislation, they excluded from they removed from the exclusion of the definition of mental disorder language which said you couldn't be classified as mentally disordered by reason only of sexual deviancy. And the government, which was New Labour at the time, made it plain that the reason for getting rid of that language was so that paraphilias could be included within the definition of mental disorder. That was the precise aim. So it links up. So yes, if you are a dangerous sexual offender, you will now be detained under the mental health legislation at the end of your prison sentence.
I just wanted to maybe call us back to Parliament and engendering a positive culture in Parliament. Now, obviously I'm an outsider, but I do know a little about the Australian scrutiny legislation which has just been brought in. So there's statements of compatibility which have to be tested against 9 UN conventions, which is perhaps too much for Australian, it's too much, 9 UN conventions. And the initial feedback is that the quality of compatibility statements by ministers is not all that great. I'm just wondering, when we look at Parliament and the supremacy of Parliament, which is so important in the Australian context, it's the main driving principle of many campaigns against rights. What factors are there on elected representatives that limit their participation or valuing of human rights? And what incentives can you establish to have them value them? And, if we're critical about the House of Lords, we can say, is it a bulwark because it's immune from the electorate? And, that would be some things I would hear, in Europe about the House of Lords, and saying how, well, we had to turn to the House of Lords, electoral politics fails. So just some reflection on that parliamentarian's view.
Yes. It's when we started, and I was there very near the beginning of the Joint Committee and the Human Rights Act, the ministers' statements of compatibility were absurd, pathetic one-liners which said, I am satisfied that this legislation is compatible with the Human Rights Act. So there's an educative process which took a long time. They kept being sent back and right. I came to Parliament very late in life, and what I learnt is that you start off being satisfied with very small gains. And you know that as long as you're there, you will be just slogging on, getting on with pushing a bit further, pushing a bit further. And what you do all the time is work out the art of the possible. You look at some terrible legislation, you have a little meeting with people of like-minded nature, and you say, what can we get here? What of this is going to go through whatever we do, and what can we fight and change, and who will support us? And then you become a strategist, you make a little campaign, and you draft your amendments, and you start the process. But you learn that it is very incremental. That's the word I think I was looking for. A little bit, then another bit, and another bit. So if the Australian Parliament has started, and I did hear about this, being compatible with UN conventions, it will take a long time. But it needs to be energetically pursued from day one, and you will find that members of Parliament, a certain number of them, will like it. It's very interesting work. It's a way in which people can carve a niche for themselves. There's a way in which it can relate to constituents. I mean, very much. The Human Rights Committee, when I was on it, did a huge report on what we call the problems of people with learning difficulties, and that you call people who are cognitively disabled. Is that right? Same group?
Or intellectual disabilities.
Yes, yes. Well, that was a very big, important human rights issue. We did a report, lots of people came and talked to us, we made lots of recommendations. That is very meaningful to a lot of people in the electorate. We did a similar one on old people and what old people suffered in care homes and in hospitals. That's very much a human rights question and very, very relevant to the public. Human rights is not all about criminals and terrorists. Far from it. It's about all human beings, some of whom are in that category. And all that needs discussing, and there needs to be meetings in Parliament, and people need to see that in many ways it is a way of looking at the world. It is not deciding something that now it's all different. It is that you look at the world through trying to, whenever possible, assert the respect for and dignity of each individual human being. And that's quite attractive. That's not tainting or embarrassing to do. It's all a question of understanding it and presenting it. But if that could take off in the Australian Parliament, it would make a great deal of difference in the end to what happens to the subjects we're talking about here. So I think that's one of the priorities you should think about.
Hi, great panel. I've got two questions. One is about control orders. It's my understanding, I know we don't know precisely what triggered those control orders, but from what you know, is it a fact that these people hadn't committed any crime or even committed any conduct that one could be called eminently risky? That's question number one. What do we know about that? What do we know about the triggering acts, if any? And then question number two, it's sort of been a theme throughout today. Why is it that legislators, even the European Convention of Human Rights, don't seem to have any problem with long-term preventive detention of people with mental disability? We get all tied up in knots about preventively detaining other kinds of people, but as soon as we're able to attach that label mental disability, all bets are off. The European Convention actually says that detention is only permissible after a lawful conviction or for people of unsound mind. That's the language it uses, without defining it any further. And you see that kind of trend throughout the world. Now, I know what my answer to that question is, but I'm wondering what the panel's answer to that second question.
I think I'll just answer the first question, right? Obviously, everything about what the control order people were doing is secret. If it weren't, it could go to court. And I have no idea. But there are a number of arguments that have been adduced, like these were the ones that strategically they wanted to disrupt rather than to prosecute. These were the ones that they wanted them to know that they knew, because obviously a more practical approach is to put in surveillance, find out what's going on and see who you can arrest and do it properly. With these few, they decided not to, and there were reasons that a normal mortal like me would not know, but presumably that's what it's to do with. But the one case where there's a lot of detail, which was the chap that they relocated, was a Syrian. And it was all to do with something that had very little to do with the UK. And I think that with a lot of these, a number of them were Algerian, we know that, and a lot of it was nothing to do with us in a domestic sense. It was something to do with many more international ideas about what they wanted to disrupt and who other intelligence services were telling them about. So it's not in our purview to know, but I don't think there's any reason to think they weren't doing anything, if you see what I mean. They were certainly up to something, but it's not clear how serious. There was only one who it turned out had been set up by a bloke who was jealous because he was going out with someone as his girlfriend, and so they started talking about him in a pub and what he'd said, which he hadn't said, and when it all came out, the judge said this control order should never have been made. So that told you something, but for the rest of them, we don't know anything really. And the other question about the European Court and unsound mind, I'm out of my comfort zone considerably, and why should I even begin to answer it when there's one of the world's experts on the end there?
Well, the world expert is actually in the middle. I'm not a world expert on that.
Sorry, are you a world expert on unsound minds?
Can I just add something on the control order point? The secret court that's been mentioned is the Special Immigrations Appeal Commission. And it's important to know that the context, or supposedly the context, of the control orders and the reason why it got into all sorts of trouble was that it was foreign nationals who didn't have a right to stay in Britain, but who could not be deported because they would be tortured abroad. So there is that background to it as well.
But
But
you should say that by the end, every single one of them was a British national.
yeah, so that's how it started, and that it's one of those expansion. You started in one area with people who you can't deport, and then it creeps into other areas. So that's again one of the themes. In relation to unsound mind, actually, it's worse than you've told the audience, because Article 5.1e, which is the part of the European Convention that allows preventive detention on the basis of mental disorder, actually refers to drug addicts, vagrants, and people of unsound mind. And the underlying, when the European Court has been asked, for example, on the what does alcoholics mean? Does it mean people who have alcoholism, or does it mean people who are drunk? It has reached the conclusion that it means people who are drunk. You don't have to be an alcoholic, you just have to be drunk, because the underlying theme of all the groups mentioned in Article 5.1e is they're dangerous. They've said that in a case called Litwa against Poland. So, yeah, it's what it demonstrates is the importance of the Convention on the Rights of Persons with Disabilities, because there is a theme that has gone through for centuries about mental disorder and witchcraft and so on. It's something which is just evil, and it needs to be controlled. And it's not until you get the Convention on the Rights of Persons with Disabilities, which has language saying you cannot discriminate against people on the basis of...
Does that trump Article 5.1e?
No, but the European Court of Human Rights is willing to take into account other conventions in interpreting what Article 5.1e means. It's a long process because there's a sort of 50 years of the European Court allowing detention on the basis of unsoundness of mind, because it's there. And so it'll be a long time before it can ever be interpreted away, or interpreted more likely in a much more restrictive fashion than is currently permissible. But documents like the Convention on the Rights of Persons with Disabilities at least equip people with the tools to argue about that. I think that's been a theme of various conferences where I know Ian's spoken, and the possibilities of that convention are actually, you know, it's a very positive, potentially, convention.
It is, and I think that's one of the conventions that now has to be taken into account by the federal parliament here. And it is a really positive step, and it will take some time for the requirements of compatibility or incompatibility, the statements as to those to be enunciated in a meaningful way, which impacts upon the social acceptability within the legislature of different pieces of legislation. I would think it's going to be at least a 5-year exercise for that to flow through, but it's got the potential to be really constructive.
I wonder if I might comment on Chris's question, because I think it's one I've tried to throw out through the years as well. And I wonder if the answer to the question, why do we, to some degree, exempt mental disorder from all the other kind of advances we've tried to make in other areas, is simply something, Chris, you said, and I think something Arlie referred to earlier today, which is that historically we always have, and that there really is no good answer that's rooted in kind of contemporary thinking about mental illness. But if you go back, I mean, take, as you said, Chris, take your civilization, how far back you want to go. John Monahan talks about in his work on mental illness and violence how the Romans used to kind of drive people with mental illness from community to community because they thought necessarily they were violent. If you look at the work that Baronness Pescadillo does on surveying public attitudes about mental illness and what the public associates with mental illness, attitudes are virtually unchanged in terms of the association of violence and mental illness over the 30 years or 20 years she's done that work. So maybe that the answer is there really is no good answer, that it's just something we've always done, that it rests on social constructs of what mental illness is and what it represents, and that it maybe in this area more than even some of the others, it's a much longer kind of slog in terms of trying to apply international conventions, human rights principles to an area where all societies, I think there's virtually no exception, have treated mental illness as something odd, scary, and dangerous, and that there's so much history, in a sense, to deal with. Unlike virtually any other disease you could think of, or any other kind of phenomena, like terrorism arises as a sort of a relatively time-bound phenomenon, or at a point in time. So it may be that there is no good answer.
Okay. All right, Velman.
Just to continue along the same line, it really amazes me that mentally ill people are detained on the basis of their dangerous illness, that there isn't really evidence at all that mentally ill people are more dangerous than the rest of the population. And all of these statutes and mental health acts are based on risk and risk to self, risk to others, and so on. I would like to ask Ian Freckelton, I'm aware of this movement towards capacity-based legislation, which would move away from just considering the risk to considering patients' capacity when decisions are made, whether they can be treated involuntarily and so on. And I know there has been some movements in Victoria towards capacity-based legislation. Do you think that if that's true, do you think that that's the positive thing, or do you have any comments on that?
I'm not sure the two are incompatible. There's been discussion in Victoria, but no legislative movement, nor is there likely to be in the foreseeable future. There's a new Mental Health Act which is likely to go through the legislature next year. I think one has to approach the issue about the correlation between mental illness and risk to self and others carefully. It does not follow that because a person has a mental illness they are risky to themselves or others. But we do know that some persons with mental illnesses are intensely dangerous to themselves and others, or others. It's a case-by-case situation based upon clinical presentation and previous behaviour and ongoing symptomatology. So it isn't that there is no correlation. What we know absolutely definitely is that there is a close correlation for some people in some contexts, and that if you add certain kinds of hallucinations and delusions to use of certain substances and certain other pressures, you have a dynamite combination, and the MacArthur studies have demonstrated that beyond doubt. What we need is a more nuanced and informed debate and application of principles in relation to the evaluation of risk, so that only those persons are detained against their will, either in the community or as inpatients for as short a time as possible, when treatment is likely to have some meaningful impact upon the precipitating risk. But that's the sort of thing one could have another full day or more about, Patrick, and no doubt we probably will at some time.
For more information, visit bond.edu.au/iTunesU.